Good morning. Good morning to you all. Good morning, everyone, wherever you are across South Africa and internationally as well. I trust everyone is keeping well. I trust you are keeping warm. I think at this rate, the weather needs a code of conduct of its own because, wow, it's starting to get a bit personal. I hope you're looking forward to an informative and exciting session this morning. Welcome to the South African Council of the Architectural Professions Code of Conduct webinar of 2026. As we accept more attendees to join, and before we get to the crux of things, I'm sitting here and I'm reflecting on why is it that we are here? Why are we here? Why is this webinar so important? And I think to myself, we often spend our careers helping clients stay within budget, helping clients stay within the program, to stay within the regulations. So today's session is about helping us, helping ourselves stay within our own code of conduct. We spend our careers telling contractors to follow the plan. Stick to the prescribed specification, Mr. Contractor. Stick to the detail. So today's webinar is about the profession's way of saying, perhaps we should follow a few plans of our own. We are trained to normally think outside the box. The code occasionally reminds us that there are a few boxes we shouldn't think outside of. Registered professionals spend many years learning how to design buildings that stand the test of time. Today's session is about ensuring our professional conduct is built on foundations that are just as solid. Ethical practice is a bit like good architecture detailing. When it's done properly, no one notices. But when it's done badly, everyone notices. So the purpose of today's webinar is to help everyone stay on the right side of the code of conduct. It's much cheaper than meeting us through the disciplinary processes, trust me. But before we begin, I would like to reassure everyone that despite despite today's topic, there will be no surprise compliance tests at the end of the webinar. So your CPDs are safe with us. But on a serious note, thank you all for joining us. The Code of Conduct is more than just a set of rules. It reflects values, it reflects professionalism, and it reflects the public trust that underpin our profession. So today's session is an opportunity to reflect on those responsibilities and how they guide our daily practice. My name is Singalaka Bongela. I am a registered architect by profession. I'm also a council member in the sixth term. I'm also very honored to chair the investigating committee at SACAP. Speaking of SACAP, SACAP's mandate is one to serve its registered persons. And when I say registered persons, it's everyone across all boards, including candidates, including apprentices. When you're registered with SACAP, we are here to serve you. When I say registered professionals, though, it is, however, those that are legitimately allowed to practice independently, exclusive of candidacy, exclusive of apprentice. So this mandate is to serve as registered persons and also to protect the public. The protection of the public part of that mandate is the responsibility of the investigating committee. Ours is to ensure professionals comply with the code. Ours is to ensure that registered persons that are found guilty of improper conduct, they follow the right disciplinary processes, they follow the right sanctions where necessary, charges where applicable, and possibly deregistration if the outcomes are that way. So I may be the one visible on the screen currently, but I don't walk alone. I'm a part of a larger team of individuals. We are registered professionals. We have legal compliance officers. We have investigators. We have prosecutors. This whole team is formulated. It is dedicated. Its sole mandate is to protect the reputation of the architecture profession. So, on behalf of South African Council of the Architecture Profession, it's my pleasure to welcome you to this webinar. We are delighted to have practitioners, we have candidates, we have students, we have stakeholders, and members of the profession joining us across the country. Your participation demonstrates, one, a shared commitment to maintain the highest and ethical conduct within architecture. So today's webinar, we'll be presenting it a little bit different from our usual webinars for the code of conduct. Usually we'll give you a PowerPoint and say rule number one, rule number two. But however, today we thought we'd introduce some case study aspect. When you hear a narrative and a story, you remember it a lot better than something that's so stringently put. So we'll introduce matters that have led to disciplinary hearings or tribunal where registered persons have been found to have improper conduct that have led to sanctions. And for me, the word sanction is a very soft word. Sanctions are charges, um, and each charge may carry either between 10,000 and 20,000 rand. For me, that's a lot of money. So the word sanction seems quite light. These are charges. I'll give you an example. So if a member of the public comes for one complaint about a registered person, example, I paid for plans for this draftsperson and I didn't receive these plans. So what we do as SACAP, we open up your profile. For instance, it's Pete Lambert or Tabo Pesta. Or well, maybe not Tabo Pesta. We don't have that jurisdiction to charge. So let's say Pete, we open a file. Firstly, are they registered with SACAP? Is the first thing we look at. If they're not registered with SACAP, we take them to the department that deals directly with the SAPS. It's a criminal offense to practice architecture if you're not registered with SACAP. So let's say Pete is registered with SACAP. Firstly, we look, are you CPD compliant? Are you currently up to date with your CPD cycle? Then we realize, okay, Pete last updated his CPD in 2023. No, he's not compliant with CPDs. Charge number one. Did they get into the contract according to a code of conduct? 4.1. 4.1 lists the requirement that you need to have. You'll hear that presentation today. 4.1 lists the requirements that you need to have to enter into a contract. Then we realize, oh, okay, Pete gave his client a quotation. That's not sufficient. That's two charges. Then we'll have a look at the quote. We'll say, client, please send us all the information that Pete gave you. So we'll look at the quote and we'll see the letterhead. Oh, the letterhead doesn't conform to the prescriptions of our Rule 511. There's aspects and elements and information that must be present on all your letterheads and information you send to your clients. So that's 3 rules already. Then we'll look, okay, Pete Architects, the company, was it registered to SACAP within 30 days of opening it? We'll go to CIPC. We'll see when it was registered. We'll see, no, within 30 days of registration, Pete Architect didn't register the company to SACAP. That's charge number 4. Then we'll look through. We'll look at your Facebook. We'll look at your Instagram, your LinkedIn, your Twitter, your TikToks. We'll check your Snapchat. Do they inform the public that they're an architect? And upon us looking at the registration, no, Peter is registered as an architectural technologist, but to the public, he's presenting himself as an architect. That's charge number 5. So in the ranking or a rate of 10 to 20,000 rand, you've got 5 charges. That's before we even have looked at why or how you weren't able to perform your duties to your client. That's a lot of money. That's why I say we need to get you on the right side of the code of conduct, and it's far cheaper to be here, to be in this webinar, than to be in the disciplinary process. So we are currently here to ensure that before we get to all of that, as SACAP, let's first serve our registered persons. Let's educate. Let us bring awareness. Let us highlight the importance. Let us reiterate the understanding of the code. So that's why we're here. Thank you for taking the time to join us today. We do look forward to a productive session. So the compliance officers, the prosecutors, the investigators, they are going to now take you through all the rules and their presentations. The program is going to go in that manner. At the end, there will be a questions and answers section that will be held. Please limit your questions to code of conduct discussions that have been specifically said in today's webinar. We also have a chat box. In that chat box throughout the presentation, if you have any questions, please put them in the chat box. We will try and answer them throughout. Without further ado, let's firstly start. Actually, how do we access the latest code of conduct? As professionals, although we are willing to charge you, let's allow you the privilege of knowing exactly where to find the latest code of conduct. Our latest code is Board Notice 7 of 2021. I'm going to then allow Ms. Bessie Hlophe, who is our Senior Legal Compliance Officer, to take us through where we find the code, and then we'll start getting into the individual rules. Thank you and enjoy.
Thank you, Madam Chair, and thank you, everyone. Good morning, everyone. I just want to do a virtual showing of where we can find the code of conduct. Thank you. Thank you so much. Again, good morning to you all, and thank you again for joining us today. The work of the architectural profession is guided not only by technical standards, but also by ethical principles. At the heart of this framework lies the Code of Conduct, a document that safeguards the integrity of our profession and ensures public trust. We are starting off this session, as the chair mentioned, by showing you exactly where and how you can access the Code of Conduct. Whether you are preparing for practice, responding to a query, or ensuring compliance, knowing where to find this document is essential. Ms. Manuku, can you just go back for me?
Sorry, where should we go? Next page.
Yes, can you just go back? Okay.
This one.
No,
Is it
okay,
fine?
let me help you. It's okay, let me help you, ma'am.
Okay.
Let me help. Okay. There we go. Okay, everyone, as you can see on the screen, hopefully you can see, to find the Code of Conduct document, you can please go to the SACCUP website. We have the link showing there in color for you. And then you can just go under regulation. After regulation, you will then see the rules of inquiry as well as the code of conduct. There you can see on the right-hand side, you can be able to download the code of conduct and save it and then be able to use this document. Obviously, you need it for your everyday use. This will guide you. And also this will also be covering most of the rules that we'll be getting into today. So if you have a copy, you can just be able to highlight as well. Thank you so much, Madam Chair. Thank you, everyone.
Thank you, Ms. Bessie. So there we have it. You can have full access to the code of conduct through our website. The code shouldn't be something that you print and it stays in your file and collects dust over the years. It must be on your table, always accessible, as this is how we serve the profession on a daily basis. All right, we'll move over then to rule number 1.1, our very first rule of our code of conduct, honesty, integrity in the architectural work. I'll allow Ms. Kakgelo Mashile, who's our legal manager, to take us through rule 1.1. Thank you.
Thank you so much, Madam Chair. now that we have access to the code of conduct, now how do we avoid non-compliance? I will be taking you through Rule 1.1 as well as 1.2 of the code of conduct. This rule speaks to honesty and integrity in the architectural world. And then Rule 1.2 speaks to the integrity and your professional conduct. And then what I'll also be doing is that I'll also be touching on the common disciplinary tribunal complaints that we receive, as well as the practical lessons that you can take from those complaints that we receive. And I'll also speak to the importance of ethical conduct and accountability. And also I will look at the maintaining professionalism and also the public trust as architectural professionals. Then I will move to the next slide. If the next slide is here, I am looking at Rule 1.1. Rule 1.1, we've seen that it's mostly contravened because there is a misrepresentation of registration category or qualification. And also, registered persons are signing work without properly supervising the work. And then we've also seen that this rule is contravened because of false and misleading municipal submissions. A registered professional will say, I've submitted the plan, only to find out that the plan has not been submitted. And then also we've seen that it's mostly contravened when registered persons are using another professional SACAP details. For instance, you know that you are a technologist, and then you see the work that, okay, this work is reserved for a professional architect. Now you use registration numbers that are not yours. So we've seen that this rule is contravened by those conduct. And then also we've seen that there is some dishonesty during investigation. The Madam Chair has taken us through complaints that we receive and then the process as well. So we've seen instances that during the investigation process, there is dishonesty from our registered persons. And then if you are dishonest during that time, you might be found to be contravening Rule 1.1. Just for interest sake, maybe let me just read Rule 1.1 from the Code of Conduct that you will be accessing through the link that was shared earlier. Rule 1.1 specifically says that a registered person shall take into consideration the standards of honesty and integrity that underpins this code of conduct when performing architectural work. Like I've said, speaking to honesty and integrity as a professional architect performing architectural work. Then we'll move to Rule 1.2, and then we look at instances where Rule 1.2 can be contravened. But let me just read Rule 1.2 so that maybe you can understand. Is that a registered person shall at all times act with honesty, integrity, and avoid any action or situation which may be detrimental to the esteem and dignity of the profession or conduct which brings the profession into disrepute. So usually this rule is contravened by the following conduct, and it actually speaks to, just when you summarize it, it speaks to the integrity and your professional conduct. So this rule is usually contravened when registered persons just have a pure communication with their client. You were fortunate enough to have a client, but now you are poorly communicating with your client. So these are instances where you can contravene this rule, or else there is an aggressive or abusive correspondence between yourself and your client. Again, you're fortunate enough to have a client, but now you are aggressive, and then there's an abusive correspondence. You are avoiding your client. So these are instances where you can contravene this rule. And then also failure to honor your professional commitments. We've seen quite a number of this contravention. All in all, most of the complaints that comes to SACAP, they actually comes from failure to honor your professional commitment. You have been paid a certain amount of money, there have been an agreement, but now you are just not doing what you have committed to do. So these are instances where you can contravene Rule 1.1.2. And also, there are instances where there is just disrespectful conduct during disputes. So now you and your client have a dispute, but you are just being disrespectful towards your client. So if it comes to our desk, chances are you will be contravening Rule 1.2 of the Code of Conduct. And then also, conduct just brings the profession into disrepute. I believe that we all understand that. You know when you're doing something wrong. And then these are instances where you can bring the profession into disrepute. As a registered profession, you are carrying the architectural profession. So you must make sure that you conduct yourself in a professional manner and then not bring the architectural profession into disrepute. So if you are found to be bringing the architectural profession into disrepute, chances are you might be found of contravening Rule 1.2. And then now I want to look at the key lessons from the disciplinary cases that we receive. So we have seen that we receive quite a number of complaints from, you can go just a little bit back, thank you. So we've seen that we receive quite a number of complaints from members of the public because they trust registered persons to prepare their architectural work. So we see that most complaints actually do not arise from they don't arise from your technical competencies. So we understand that you guys are competent, you have gone through all the competency level, but the problem is just how do you conduct yourself in a professional manner. So to avoid this, just make sure that as much as you can draw, just conduct yourself professionally. If you have to write it down, the way you don't want to be spoken to, don't speak to someone like that. And then also we've seen that the communication failure, registered persons have this pattern of not wanting to communicate with their clients. So what you can do is that frequent communication. One of my colleagues will be taking you through the specific rule that deals with communication. So frequent communication, when you're sent a WhatsApp, just respond. If you're not able to respond, say it in the WhatsApp, I'm not able to respond to you now, I will respond later. And please, when that later comes, please do respond. But what you need to do is that constant communication with your client. It is the client in knowing that their money is in the right place, their faith, their dream houses are in the right hands. So what you do is that please frequent communication with your client. And also we have seen that profession have this professional, so to say, they have this mentality of not wanting to take accountability for the work that they've signed. So as soon as I think architectural professionals, they are fortunate because they have a registration number that belongs to them. And then we all understand that what can a signature do for you? A signature can make or kill you. So we've seen instances where professionals just want to sign. You just want to sign, but you don't want to be accountable for what you sign. So the key lesson that you can learn today is that each and every time you put that $1 million signature on whatever document, you are actually taking responsibility for that work. So you need to make sure that you have supervised that work, you understand what is on that plan before you sign the work. So each and every time you sign something, you are taking full accountability for it. So what you can learn today in terms of the disciplinary tribunal cases that you've received, take accountability when you sign. If you can't take accountability, then don't sign. So that's what I think you must also learn. And also you've seen that honesty and transparency is very essential. If the plan has not been submitted, just be transparent and honest to your client. If you have issues in terms of submitting the plan, honesty is the best policy, so they say. Just say to your client that I was unable to submit the plan, and these are the reasons. Be transparent, and then if you are honest and transparent, I think maybe even at SACAP we will receive less complaints. So honesty is the best policy, and transparency, it always assists you as a professional. And then also you've seen that professionalism is not maintained at all times. So you need to be professional. This is a profession. I know that we have clients that are unreasonable, clients that are emotional, but for you, you are a professional at the end of the day. You must be professional at all times. So be professional, even if you think you're about to lose your temper, but just maintain the professionalism, because at the end of the day, you are the professional and the member of the public is considered a layman in your profession. So maintain professionalism at all time. And I think that will be the end of my explanation in terms of rule 1.1 as well as 1.2. Hopefully we will not be seeing any contravention of these rules. Thank you for your time. Thank you.
Thank you, Ms. Mashile. Colleagues, we have seen Rule 1.1 and 1.2. These are the backbone and foundation of who we are as professionals. It's important to have ethical conduct and accountability. What you say, what you write, it is regulated, always needs to be honest. Do not fail to honor professional commitments when you've committed them to your client. In times of disputes, do not be disrespectful to your client. You represent us all as registered professionals, and do not bring the profession into disrepute. That ends those two rules. We'll move on then to Rule 2.1, skill, diligence, and competence. This will be presented by Mr. Sfanele Matebula. Mr. Sfanele is our prosecutor. You can get an email from anyone, but when you get an email from Sfanele, you know you're on the wrong side of the track. Mr. Sfanele, take it away, sir.
Thank you, Honorable Director. Greetings to the attendees. Protocol is observed. My presentation for now will be on Rule 2.1 of the Code of Conduct. It is important, colleagues, to understand what this rule provides for. If I can just read out. Rule 2.1 provides as follows: registered persons shall discharge their duties to the employer, client, agent, associate, and the public with due skill, diligence, and competence. I think, colleagues, as a point of departure, we need to look at the wording of the rule. If we interpret the word shall, it tells you that you are mandated. This is a mandatory thing to do. It is not up to you to exercise discretion whether or not to comply or how you feel about the rule. But you are mandated at all times to comply. So therefore, every time when you are conducting or discharging your professional work as an architectural professional, you must discharge your duties with skill, diligence, and competence. Now, colleagues, as SACAP, we do receive complaints from members of the public from time to time. These complaints are against persons who are registered both as candidates and as professionals. Most of the complaints that have to do with the contravention of this rule, you find that oftentimes our registered persons, they fail to acquaint themselves with the sites of their clients before they undertake the work. It then results in many amendments that need to be done in the work. And sometimes you as registered fail to perform these amendments that would be required by the local authorities. What then this translates to? It translates to incompetent work on your part. It translates to unhappy clients. It translates to your clients losing their money. And as well, it translates to you as a professional being sanctioned by the tribunal. Now, colleagues, if you have been subjected to the disciplinary tribunal and you have been found guilty, Section 32, Subsection 3A of our legislation provides for the various kinds of sanctions that may be meted against you. The first one is a caution or a reprimand. The second one would be the imposition of a fine. which does not exceed the amount calculated according to the ratio for 1 year imprisonment, which is determined in terms of the Adjustment of Fines Act. The third option would be a suspension of your registration. And the last one, and in severe cases, your registration as a resident person may be cancelled and your name may be removed from the register. Section 32, subsection 3B provides that the Disciplinary Tribunal may take decisions under more than one subparagraphs of paragraph. So it means that what I've read out above, you could be a subject to more than one kind of a sanction. For example, the tribunal can say you are cautioned, but over and above that, you are expected to pay a fine. So that is what this section 32 for subsection 3 means. Colleagues, SACAP prepared some sanction guidelines that assist the tribunal to decide what kind of sanction to make out to offending registered professionals. The minimum fine in terms of our guidelines is a fine of 10,000 rands, and the maximum fine is 20,000 rands. It is to be noted, though, colleagues, that the tribunal may use its discretion to deviate from this guideline. So this means that in as much as the guideline provides for a minimum fine of 10,000 rands and a maximum of 20,000 rands for a contravention of this group, the tribunal itself, looking at the severity of the theft, may disregard this guideline. You could find that they may impose a sanction, say, of cancellation of your registration. That is the essence of what I'm trying to explain to you. Now, colleagues, the key lessons that I learned from the Disciplinary Tribunals, this is some sort of a recap. We have got registered persons who are appointed to prepare building plans and submit to the municipality for approval. The registered persons, they fail to acquaint themselves with the site. In the result, registered persons prepare incorrect plans which need various amendments. The project gets delayed and the client gets frustrated. The lesson then, colleagues, is that at all times, registered persons must approach each project with diligence, skill, otherwise the clients may lodge complaints which may taint the image of such professional. I thank you, colleagues. That is the end of my presentation for now.
Thank you, Mr. Matebula. Members in our boardroom, there is an echo. The sound is not very good. So can we please try and see how we can sound a bit better? We want our colleagues to hear every word. So that's 2.1. Well, you can attend to that. Rule 2.1, skill, diligence, and competence. So it's important to have due skill. Don't cut corners. Do your site inspections diligently and ensure all the details and all the information is on your drawings and is on your documentation. We'll move over then to Rule 2.4. This is pertaining to mentorship and candidates, 2.4 and 2.6. And these rules will be presented by Ms. Neo Malachi. Ms. Neo is our Legal and Compliance Officer at SACAP. Ms. Neo, you have the floor, ma'am.
Thank you, Madam Chair, and thank you
To everyone. Sorry, there's an echo.
Boardroom, can you put your sound off, please?
Madam Chair, is that better?
Let's carry on. Maybe it will get better.
Okay. Thank you, Madam Chair. Thank you, colleagues and all present. Today I will discuss the code of conduct, the rules that govern candidacy and mentor responsibilities in the architectural profession. It's very important to note that these rules, they safeguard the professional standards by ensuring that candidates are properly trained and supervised. Rule 2.4 reads as follows. It says, registered persons shall, where work is carried out by a registered candidate under their supervision, take responsibility for ensuring that such candidate is appropriately registered, competent to perform the task, and is adequately supervised. Now, SECAP requires candidates to undergo structured mentorship before registration as professionals. These rules, they ensure that candidates gain practical experience and also protect clients and members of the public in the process. The key obligations of a mentor is to ensure that the duty is upon the mentor when signing that mentorship agreement. You need to ensure that whoever that you are mentoring is duly registered with SECAP. Remember, in as much as they are still under training, they have to be registered with SECAP so that we can check their progress and see if they actually then become qualified to be a registered architect or registered professional, as it may be. It is also a mentor's responsibility to ensure competence for assigned tasks in that the candidate is duly qualified and legally eligible. A mentor has to provide adequate supervision and guidance. I think it's very key to note that the mentors have a duty to train, not to just supervise, but to train, to provide structured guidance, to provide exposure to diverse aspects of training, and to various aspects of the architectural profession. Because at the end of the day, it's not just about signing off documents, but it's ensuring that we are equipping candidates with the due skill to uphold the profession. And it is a mentor's responsibility to remain accountable for completed work. Oftentimes you find that the mentors just give the work and then sign it off and it goes to council. It comes back, there's issues with it, and then it's like, no, it's not me, it was the mentor. You as a mentor, it's the candidate, you as a mentor remain accountable for delegated work. Tribunal lessons. Cases where mentors failed to supervise led to unsafe designs or non-compliant submissions. Disciplinary findings often stress that mentors remain accountable for the work of their mentees. Mentorship is both a professional safety net as well as a legal obligation. We can move to the next slide. So Rule 2.6 reads as follows. A registered candidate must perform work under the direction, control, and/or continual supervision of a registered professional entitled to perform such work and who must assume responsibility for any such work performed by the candidate. Candidates must actively engage in their training, in their CPD, and in any practical experience that they hope to achieve. And the key obligations of candidates are that they cannot work independently or for their own account. Candidates cannot take on private clients. They are not registered professionals. They're still under training. They may only work on projects as assigned and supervised by their mentor. A candidate must respect all supervisory structures, and they cannot hold any financial interest in a practice. So you can't be a co-director and still be a candidate in that practice. It is a direct contravention of the rule. Even as trainees, candidates have to adhere to the standard of integrity and competency as set out by SECAP. What tribunal lessons we get is cases where candidates signed off drawings or actors and principals led to serious sanctions. And by serious sanctions, I mean that you cannot purport to be a registered professional when you're not. That constitutes fraud, and that leads to very, very serious sanctions, because it's not just under the ambit of the code of conduct. Now, you have contravened the act itself. Candidates who were found guilty of improper conduct for avoiding supervision. It's very important for me to emphasize the fact that signing off on a candidate's drawings does not constitute supervision, does not constitute direct control. And the rule is very specific to say under the direction, control, and or continual supervision of a registered professional. So it's very, very important because we've faced many incidents where candidates are doing their own thing and under the title block of a registered professional. Our candidates must accept supervision as a necessary component of their career development. So I just thought, what does this look like practically? What are the practical implications of a candidate's responsibility? It is a candidate's responsibility to ensure that they keep an accurate logbook for their experience. They seek feedback and guidance regularly, and they avoid misrepresenting themselves as registered professionals. That last one is very, very important because it leads to very serious sanctions. What are the key takeaways that we got from tribunals? If you can move to the next slide. A professional architect allows a candidate architectural technologist to prepare council submission drawings independently without checking the drawings before submission. Then the municipality later rejects the plans because the fire escape requirements were incorrect. In this situation, the candidate may have made the mistake, but the professional architect can still be held accountable because they failed to properly supervise and review the work. What is the lesson? That a registered professional cannot simply sign off work prepared by a candidate without proper oversight. Supervision must be active and it must be meaningful. Another key takeaway or practical lesson is where a candidate architect starts a side business and independently signs and submits building plans to the council without the involvement of a mentor. Even if the drawings are technically correct, the candidate may still be guilty of improper conduct because the candidates they are not permitted to practice independently, and the work must be performed under supervision. The lesson is that candidate registration is a training category, not an independent practicing category. I thank you. This concludes my presentation on mentorship and candidacy.
Thank you, Ms. Neo. There you have it, members. Rule 2.4 and 2.6 is very clear. Mentorship is not just signing off monthly training records. The candidates must be supervised. It's your responsibility to ensure that when such occurs, because actually when candidates get found guilty, we do also charge the mentor. Please be cognizant of that. And a big one, candidates, apprentice, you may not run or own your own practice. You may not be independent. There are a set of skills that you still need to learn and develop. So please do not endanger the public. Thank you, Ms. Neo. We'll now move over to Rule 2.7. 2.7 speaks to CPD compliance, CPD obligations, which are essential in this profession. This will be presented by Ms. Boitumelo Leshabane. She's also a legal compliance officer. Thank you, Ms. Boiti.
Thank you very much, Madam Chair. Good morning, colleagues, and good morning to everyone that is joining us on the online platform. As the Chair has indicated, my name is Boitumelo Leshabane. I am a legal and compliance officer at the Sacred Legal Department. Today, I will be taking you through Rule 2.7, Rule 3.1, and Rule 5.11 of the Code of Conduct. I will begin my presentation with Rule 2.7 that deals with continuing professional development in the architectural practice. So let's look at what the Code of Conduct says. Rule 2.7 says a registered person shall regularly undertake continuing professional development activities in order to ensure that they keep up to date with developments in the practice of architecture and to enhance and maintain their professional expertise and competence. Please move on to the next slide. Now, the definition of continuing professional development refers to the ongoing process of learning, training, and professional growth undertaken by professionals to maintain and improve competence, knowledge, and skills through their careers. It is therefore important for professionals to always remember that professionalism is not about knowing everything. It is about committing to the standards, ethics, and continuous improvements that inspire confidence and trust. We have, there are a number of reasons why CPD is important. But at SACAP, we've identified just a few, a number of reasons why we believe CPD is important in the architectural industry. Firstly, CPD maintains professional competence. It enables architectural professionals to remain technically competent and capable of delivering quality professional services. It keeps professionals up to date. The architectural profession evolves continuously due to changes in the building regulations, sustainability standards, digital technologies, and construction methods. It is therefore important to ensure as a professional that you keep up to date with the changes in the industry. CPD protects the public interest. Competent professionals contribute to safer buildings, compliant developments, and improved public confidence in the profession. CPD promotes lifelong learning. It encourages architectural professionals to continuously improve and adapt to industry changes throughout their careers. Finally, CPD enhances career growth. Participating in CPD activities improves leadership, technical expertise, innovation, and employability. The next slide. There are also legal and ethical obligations that are placed on our professionals under Rule 2.7. On the legal side, Rule 2.7 is clear. It states registered professionals are required to regularly undertake CPD activities to remain informed about developments in the architectural practice. CPD compliance may be required for renewal of registration, maintaining good professional standing, and demonstrating competency during investigations or disciplinary matters. On the ethical side of things, architects have an ethical responsibility to act competently and diligently, to avoid professional negligence, ensure services meet acceptable standards, and that they stay informed about legal and technical developments. Registered persons are also required to protect the dignity and the integrity of the profession. Now, failure to comply with Rule 2.7 may give rise to consequences. These consequences will come to play in the form of disciplinary proceedings with penalties and sanctions being imposed. It may also create reputational harm or reputational damage, not only on the professional, but also on the reputation of the profession. There may also be questions regarding professional competency by prospective clients, current clients, as well as counsel. Madam Chair will know and will attest to this during our investigating committee meetings. We are always concerned if we realize that a registered professional has not complied throughout or a few cycles of their CPD cycle, they have not been compliant. That is always a concern. In light of the provisions of Rule 2.7, SACAP encourages all registered professionals to view CPD as an investment in their professional future and an opportunity to continually improve the quality of services that they provide. Thank you very much, Madam Chair.
Thank you, Ms. Boiti. Colleagues, we've heard the importance of CPD. It keeps all of us updated with the latest codes, the latest trends, SANS regulations. We are moving in an ever-changing, we're actually in an ever-changing profession. AI has recently impacted us. This is to teach you how do we get to the latest trends and requirements. Please be up to date with your CPD cycles. So we'll now move over to Rule 3.1. 3.1 speaks to communications and marketing and lessons as well from disciplinary tribunals. Colleagues, we see some hands being raised here and then. Please ask your question in the chat box. There will also be an opportunity for us to have an interactive questions and answer section when the presentations have been done. Please keep that in mind. All right, Ms. Boiti, Rule 3.1, please.
Thank you very much, Madam Chair. Continuing to Rule 3.1 of the Sacred Code of Conduct, this focuses on honest promotion of professional services. If we look at the provision of Rule 3.1, it provides as follows. Registered persons may only communicate and promote themselves and their professional services with honesty, describing both in a manner that is related only to the work of the professional categories of registration represented in practice. Now, the purpose of this rule is to protect the public from misleading information, promote ethical marketing and advertising, maintain confidence in the architectural profession, and ensuring professionals represent their qualifications accurately. It is therefore always important to remember honesty is the best policy. The next slide. Now, there are three principles or three key principles of Rule 3.1. Namely, it's honesty, transparency, and accountability. In relation to honesty, registered persons must provide truthful information about their qualifications, accurately describe their services, and avoid exaggerating expertise or experience. With regards to transparency, registered persons must clearly indicate professional registration categories, and they must further explain services offered within the scope of registration. Lastly, with regards to accountability, registered persons must take responsibility for all promotional material published by the practice. Next slide. Are we still able to view?
We are sorry for the technical glitch. Ms. Seku will be sharing shortly. Just 1 second, Ms. Boiti.
Thank you very much, Ms. Seku. Why is Rule 3.1 important? Rule 3.1 is important because of the protection that it offers to the members of the public. Clients rely heavily on professional representations when appointing architects. Secondly, Rule 3.1 is important because it offers protection to the profession. Misleading advertising damages public trust, it undermines professional standards, and creates unfair competition. So from a regulatory compliance point of view, failure to comply with Rule 3.1 will give rise to complaints of improper conduct, investigations by SACAP, and possible disciplinary proceedings. What constitutes honest promotion? So here we have provided practical examples of instances where a professional will be regarded as having complied with the provision of Rule 3.1. That a professional would have accurately stated registration category, they would have advertised services within the registered scope of work, truthfully presenting qualifications and experience, displaying completed projects with proper attributions, and using factual and verifiable marketing content. This individual in this scenario would have been regarded as being compliant with the provisions of Rule 3.1. Now, the next slide deals with instances where a registered professional would be regarded as having not complied with the provisions of Rule 3.1. If the registered professional claims expertise that they do not possess, misrepresenting registration status, exaggerating project involvement, advertising services outside the category of registration, using misleading titles or descriptions, and creating the impression of competence beyond actual qualifications. Practical example in this instance would be an architectural draftsperson or a professional draftsperson who calls themselves an architect when advertising their services. In that instance, the individual would have contravened the provisions of Rule 3.1 of the Code of Conduct. The risk herein is that clients are misled, there is reputational damage, and professional misconduct complaints may be lodged against a specific individual. Lastly, I'll reiterate the consequences of non-compliance with Rule 3.1 of the Code of Conduct. There will be complaints lodged with SECA. Investigations of alleged improper conduct would be initiated. This conduct causes reputational damage to the individual as well as the profession. Disciplinary proceedings may be taken against the specific individuals, and possible sanctions may be imposed by SECA. It is therefore always important for registered professionals to remember ethical promotion protects both the public and the profession. Thank you very much, Madam Chair.
Thank you, Ms. Boiti. Colleagues, we've heard the breakdown and explanation of Rule 3.1. You know, in other professions, a doctor is a doctor, a nurse is a nurse. The public is fully aware what those two categories and responsibilities are. So from a public's perspective, anyone who draws, you're an architect. So it's your responsibility to share your category of registration and work accordingly. Our IDOW specifies what type of work you should do. So don't use the public's perspective to promote you in a higher category than you are. Let's protect the public. Thank you. Then we'll move over to item number 7. This is Rule 4.1, written agreements. Mr. Matebula will take us through. Thank you.
Thank you, Chair, once again. Indeed, I will discuss Rule 4.1 of the Code of Conduct, which relates to written agreements. Rule 4.1 provides as follows. Registered persons shall ensure that before they undertake any professional work, they have entered into a written agreement with their client, which must inter alia include proof of professional registration, the scope of architectural work, the scope of service to be provided, the allocation and limitation of responsibilities, the fees payable for the architectural work or services, the method of fee calculation, if appropriate, and the stages at which fees will be payable, the budget, if applicable, and other cost limit for the project, work or services, and the method and implication of estimating costs, provision for dispute resolution, termination of the agreement, details of professional indemnity insurance, including the name of the insurer, the name of the insured, the amount of cover, policy number, and validity period. Colleagues, on the reading of this rule, one realizes that there is once again the use of the word shall, which tends to indicate that this rule is mandatory. It is not discretionary at all. Maybe before I even proceed to the next slide, I must indicate, colleagues, that you see the importance of complying with Rule 4.1 saves you as a professional as well as your client in many ways. If one were to borrow from the words of the chair, compliance and not taking shortcuts is much, much cheaper than what you would then face in the disciplinary tribunal. We have situations where our professionals fail to adhere to this rule. And the very professionals, sometimes when they are now having disputes with their own clients, they call SACAP to seek guidance. For example, you would have a professional who is saying to SACAP, there is now a dispute regarding the payment of fees. How should they go about it? Meanwhile, Rule 4.1 itself provides for professionals to include in their contracts a clause that relates to the fees that are payable for architectural work or services, the method of calculation, and the stages at which fees will be payable. I'm just making this but one example to indicate that, if you follow this rule to the T, you are actually going to salvage a lot of problems that may come in when you're having disputes with your clients. Actually, you could find that when you are fully compliant with this rule, all of the questions that you tend to throw at SACCP, the answers are already there. It's just you just merely need to comply with this rule, put everything in the document, and then when there is any issue, you simply refer to your contract and you find your answers there. I will then proceed to the next slide. So our common contraventions of Rule 4.1 are that registered persons firstly do not conclude a formal written contract between themselves and their client. The professionals, they rely on verbal communications with their client, and this presents problems for both the professional and the client once there is a dispute between them. This speaks to what I was just alluding to before. So in other instances, you find that our registered professionals will consider their invoices to their clients to be the valid terms of appointment. However, our registered persons fail to include all mandatory clauses as required by Rule 4.1. An example of this would be the failure of registered persons to include the termination clause, the dispute resolution clause, and the professional indemnity clause. These three clauses that I've just highlighted now are the most common clauses that are left out in the agreements that professionals conclude with their clients. You will often find that professionals have disputes with their client. They don't know what to do. They don't know where to go. Meanwhile, if they had put in their own contracts how disputes would be resolved, that would easily resolve their problems in the sense that they would just look at the contract. If the contract, for example, provides that if there's any dispute, it will be sent for mediation by a third party, that would solve the problem. Or if the dispute would be solved by going to the relevant courts with the competent jurisdiction, that will also solve the problem. If all parties know what is it that they need to do in the event that there is a problem. SACCP did develop two contracts that registered persons can use as guidelines in their dealings with the members of the public. The contracts can be downloaded on the website. There is one for high complexity projects and one for low complexity projects. So if you go to our website, you'll go under documents and then project agreements. You will find those two documents there. Now, what does it mean then if one is found wanting by the tribunal or failure to comply with Rule 4.1? The sanctions are the same as having been discussed before, in that there would be the imposition of a caution, the imposition of a fine, or the suspension of registration, and ultimately, in most serious cases, the cancellation of registration. And it is also important to note that the tribunal can take or can make out more than one sanction from these ones discussed above. And then in terms of the sanction guidelines that SACCP prepared, you will find that the minimum fine that may be imposed for contravening Rule 4.1 is a minimum of 10,000 rands and a maximum of 20,000 rands. Again, the tribunal may use its discretion to decide which sanction is most appropriate. Now, key lessons learned from disciplinary tribunals. Registered persons are appointed to prepare building plans and submit to the municipality for approval. Then the registered persons fail to reduce the agreement into writing. They tend to rely only on WhatsApp text and invoices. Misunderstandings then develop due to uncommunicated, unrecorded expectations, rights, and duties. The project gets delayed and the client gets frustrated. The lesson learned then is that registered persons must ensure to put all terms of agreement in writing. and incorporate all the clauses as required by Rule 4.1. Clients must know when the agreements may be terminated, and in the event of dispute, the written agreement must give direction as to how the dispute will be resolved. I thank you, colleagues. This concludes my presentation on Rule 4.1.
Thank you, Sfanele. In our cases, I think we get an average of about 10 to 15 cases a month. And 99.9% of our RPs get charged with Rule 4.1. The information that is required in a contract, it's there in our regulations, it's in black and white. All this may seem like an administrative nightmare, that you think it's better to just send the quote and they say yes, and then you continue. But all of that also protects you as a registered person. Please ensure you comply with Rule 4.1. All of those are necessary. As I say, 99.9% of cases, we charge 4.1. That's 10,000 Rand. Please ensure you comply. All right, colleagues, I think now it's 6 minutes past 10. It will be time for just a bit of a body break. Let's allow everyone to grab a cup of coffee, grab a glass of water, go to the bathroom. We come back at 10:15, please. Thank you. All right, colleagues, it is 10:15. I hope we are all back and ready to continue. Our next rule of discussion. If you can all be seated, thank you, in the boardroom. Our next rule for presentation is Rule 4.14, Client Communication. Thank you, Miss Neo. Miss Neo will take us to that one.
Thank you, Madam Chair. Thank you all. I will now focus on the rule that requires registered professionals.
Sorry, Miss Neo, before you continue, can we maximize the screen, please, to a full view screen of the presentation?
Sure.
Thank you.
Thank you. I'll now focus on the rule that requires registered professionals to keep clients properly informed throughout the architectural process, throughout whatever project they're busy on, because communication is not just courtesy, it is a professional obligation. So Rule 4.14 of the Code of Conduct stipulates that registered persons shall keep their clients informed in writing about the progress on work undertaken on their behalf within a reasonable time and of any issue which may significantly affect its quality or cost and any other considerations which may substantially affect the project. Communication rules ensure that clients are empowered when making any decision on their project. So, as you can imagine, any failure to communicate can lead to dispute, it can lead to mistrust, and it can eventually lead to disciplinary action. So why communication, written communication matters, and I need to emphasize written communication. A lot of the times we find matters that come before us and it's a he said, she said situation, and it causes great difficulty in our investigation process, as you can imagine. So written communication is essential so that even if a client says you have done something wrong or you have not communicated, you have written everything down. So why written communication matters? It ensures accountability. Written records protect not only the client, but the architectural professional too. It also ensures transparency, which builds trust and prevents any misunderstandings, and it creates a legal protection. Written updates can serve as evidence in any legal or project disputes because, as I'm sure most of you are aware, these matters sometimes proceed beyond SACAP and into court corridors, high court matters sometimes, depending on the value of the project. So it's very important to protect yourself legally by keeping your communication to written communication. What are the key elements of this? Regular written reports regarding any milestone in the project. Inform your clients of any quality issues immediately and inform them of any cost implications. Always notify your clients of any budgets, changes, or risks, because sometimes you begin with one budget, but inflation or fuel prices currently, all of that, they affect the cost of certain things. But in as much as it can be understandable, it is very imperative to ask your client to inform them and get their consent to proceed with the new costing. And other considerations would be ensure compliance with regulations and address any environmental concerns relating to the project at hand. So, sample progress report. Have a clear structure. Your work, your work summary issues, your cost updates, your milestones. This is just an example of a development report. This will help you in the case of any disputes or misunderstandings. client communication best practices. So before I go into those notes, I just want to state that it's very important to provide your client with regular, not just overall, but regular updates on the status of the project, whether it be at municipal phase. Sometimes architectural professionals are also appointed as project managers on various projects. So it's not just about architectural aspects, it's about what are you appointed as, and are you keeping your clients updated with regards to the entire aspect of your responsibilities and the status of whatever you've been appointed to do. It's important to inform your clients of any delays, any cost implications or regulatory issues. Sometimes there's change in regulation, and it is your responsibility as a professional to inform your client as a layperson. And you need to ensure that your client not just inform them, but ensure that they understand the approvals that are required, the municipal approvals, the heritage approvals, the HOA approvals, etc. Document this communication. Ensure that there is clear understanding. Use simple terms in as far as is possible. So client communication best practices would be that clarity beats creativity. So simplify any technical languages, like I just said. Listen before you design. Ask deeper questions so that you are very clear as to your understanding of what is required by the client. Set your boundaries early. By this I mean define your scope, define any revisions in writing. Communicate like a consultant. So guide the client, don't just execute. Sometimes clients think something, but it's not really possible or legal or permissible. So it is your duty to guide the client through the process and to also follow up post the project. This builds loyalty and possible client referrals. So it's good not just for compliance, but for your business and future endeavors, possibly with these clients. What are the benefits of compliance? The benefits of compliance would be stronger client relationships, like I've alluded to, reduce disputes and misunderstandings, enhance professional reputation, alignment with SACEP's values of integrity and diligence. And Rule 4.14 actually ensures that clients are empowered through information. You know, sometimes, like the saying, knowledge is power. Sometimes you think you want something, sometimes you think something is possible, but then you change your mind because you are duly informed. And it helps not only the client, but you also with the execution of whatever is required. Clear written communication ensures trust and professionalism. An informed client is an empowered client. Now I'm going to go into the practical examples and lessons from disciplinary tribunals, but also what are the practical implications of this clear communication is written progress reports or meeting minutes. We overlook those things because we think, you know, it's construction. And have your meeting minutes recorded, have clear timelines set in writing, and have transparency about any risk that could be related to the project and your responsibility and the client's responsibility in any project. The key takeaways or lessons from tribunals is failure to provide progress updates. Clients become frustrated when they are not informed about project status, approvals, or timelines. The lesson, provide regular written updates even when there is little progress. Ignoring client emails or calls. We've had many instances in tribunals where clients are frustrated because the professional is ignoring their calls. And sometimes clients can be very persistent, and you know that could cause a disruption in a professional's day. But it is still your duty to ensure that you attend to it, even if it's not immediately. Return calls, return messages. Acknowledge communication promptly and provide timelines for feedback. Not explaining delays, another big one. Clients may suffer financial and operational impacts due to project delays. But if you inform them ahead of time, then they're able to also make the changes because your client is sometimes somebody else's client, and then they're able to adjust accordingly. So inform clients immediately of delays, causes, impacts, and revise timelines. Unexpected cost escalations. clients often dispute additional costs that were not communicated in advance. So advise your clients in writing of any cost implications before proceeding. And like I said earlier, we are aware that these things do tend to change, but there's nothing that you lose by informing them as and when these changes occur. Poor record keeping. Lack of records weakens the professional's position during disputes or SACAP investigations. So the lesson from that is that you must keep a proper record of emails, meetings, approvals, reports, etc. Because like I said, when we have a matter and we're investigating it, we are unable to prove your point, even if you did inform the client and the client is not being honest. We cannot, he who alleges must prove. So if you allege that you did communicate, then you must prove it. And that concludes my contributions with regards to communication. Thank you, Madam Chair.
Thank you, Ms. Neo. Colleagues, we've heard the importance of communication, and as she was presenting, I remember a case recently, actually, in our latest sitting, where a client had brought a RP to SACAP because they hadn't submitted drawings to the municipality within about 3 months or something. And the RP then responded to us saying that property had to be rezoned, as well as that the process had to go to Heritage Authority. It was a building over 60 years old, and we all know that that will not take a quick 3 months. But if the RP had simply communicated to the client what the steps are, how it could possibly take, then they wouldn't have disappointed in their expectations. Communication in writing as well. And this doesn't include WhatsApps. You know, in most of our cases, we have pages and pages of WhatsApp communication. As professionals, let's diligently email the client professionally. Simple things that I've submitted the plans to the municipality. The municipality is now requiring letters from the neighbors. You know, this development will now require a water use license that's going to have to go through environmental scientist, all of that. And I like what you said, an informed client is an empowered client. That concludes Rule 4.14. We'll then now move to Rule 5.1, practice registration requirements. Ms. Selina, our legal secretary, kindly take us through, ma'am.
Thank you, Madam Chair and colleagues. I will take you through Rule 5.1, practice establishment. Any registered principal who practice architecture in any form shall, within 30 days of establishment of the practice, register it with SACAP, with council, giving full details of the practice, name, address from which the practice is conducted, type of practice supported with correspondence, registration details, name of partners, shareholders, directors, and employee undertaking architectural work. And that can be done online on your profile under the tab Register a Practice. Second slide, why rule, the key requirements. To register your practice with SACAP, you need to add your name, address, and type of practice, and your registration number. You need to disclose all individual undertaking architectural work, and also update SACAP within 30 days of any changes in a practice. Transparency, it is important. Why Rule 5.1 matters? Rule 5.1 matters because it creates client trust, you avoid disciplinary action, and practices are only run by a qualified professional, and also creates transparency. The key takeaway lesson from the disciplinary, one of the practical lessons frequently observed is that some architectural practices operate for many years without being registered with SACAP. In many instances, the common explanation provided by the professional were they were unaware of the requirement of registering the practice with council within 30 days. What are the practical concerns? Although the professional may themselves be professionally registered, the practice entity remain non-compliant with SECAP requirement. So let's all remember to list our practice with SECAP. I thank you.
Thank you, Ms. Selina. I know it's one of those rules that we overlook, but in this particular case, your practice is protected. You know, it prevents unqualified individuals from running practices. It also strengthens the reputation of the profession. And more than anything, it gives confidence that this practice is registered and is regulated by a professional body. Please all register your practices. Although you as an individual, as a professional are registered, up to date with SECAP, once you open a practice, you need to register it with SECAP. We'll then move over then to Rule 5.6. And 5.6 pertains to the association with unregistered persons. Ms. Kagielo Mashile will then take us through. Thank you, ma'am.
Thank you. Thank you, Madam Chair. I'll be taking you through again Rule 5.6 of the Code of Conduct, which speaks to professional relationship association in the architectural practice. So what does Rule 5.6 say? Rule 5.6 says that a registered person may not enter into a professional relationship or association for purposes of performing architectural work with an unregistered person unless permission has been granted by council and subject to prescribed conditions. So the key requirement for you to comply with Rule 5.6 is that a registered person shall not enter into a professional relationship or association for purposes of performing architectural work with an unregistered person or a person who's not registered in the closely allied profession, unless permission is obtained from SECAP. SECAP is not saying that you must not associate with certain people. It's saying that if you need to comply with the Rule 5.6, there are certain conditions that you need to adhere to, such as seeking permission from SECAP. I'll also explain closely allied profession and which ones are those. And now we have to understand the aim of this rule. What does SACAP want to achieve by Rule 5.6? Rule 5.6 aims to protect the public from unqualified unqualified practitioners. So SACAP is trying to ensure that people who are practicing architecture are registered with SECAP, and also to ensure that architectural work is reserved for those who are registered with SECAP. And also to take accountability for architectural work. If you are not registered, SACAP do not have jurisdiction over you. So SACAP is trying to make sure that each and every person that is doing architectural work is the one who is registered with SECAP. But we have seen instances where, okay, but I'll get to that. But we have seen instances where architectural professionals who are registered with SECAP are enabling people who are not registered to perform architectural work without adhering to 5.6 and asking for that permission. And also to look at the Rule 5.6 because it has some requirements that you need to adhere to in order for you to comply. It says that permission will not be granted where the person is disqualified from registration under the Architectural Profession Act. So here is an instance where you want to work with someone who's not registered, and then you have submitted a request to SECAP and say that I want to work with so-and-so, but this person is not registered with SECAP. Can I please have permission? So permission will be denied if that person has been disqualified from registering under the Architectural Profession Act or any other closely allied profession. And also, permission will also be denied if the person that you want to work with can register with SECAP, but they chooses not to register with SECAP. So permission will be denied in those instances. And then now we look at what is a closely allied profession. So I'll just list a few of our closely allied profession. Our closely allied profession will be the engineering council. So engineers are closely allied profession to architectural work, and I think you guys know better because you work with them every day. And then there's also quantity surveyors. You know that you can work with a quantity surveyor because it's a closely allied profession. And then project and construction management council, we have project managers, and then we also have landscape architectural council. So they are landscape practitioners. So this profession operates within the built environment and are regulated by statutory profession. So those are our closely allied profession. So what are the risks of you not complying with the Rule 5.6? Failure to comply with Rule 1.6 can result in a complaint of improper conduct. So there can be instances where at our legal department we receive a complaint against you. We see that you're working with somebody who should be registered, but they choose not to register. You are enabling an unregistered person to do architectural work. So these are instances where there will be a complaint of improper conduct, and this can lead to a disciplinary proceedings before SACAP. As my colleague has said, there is a sanction guideline that you can be subjected to, of which it can be a fine between R1 up until 20,000 per charge, as the Madam Chair has also stated. And also reputational damage. So what you know that we are obligated in terms of the Act to publish the sanction. So the vote notice is there online. So you don't want your name to unnecessarily be published. And then also loss of public trust. Also in the profession, we are going back to putting the architectural profession into disrepute, because now you are enabling somebody who is not competent, who has not been tested to do architectural work. And then also there are possible sanctions that can be imposed to us at SACAP by allowing such a conduct. So let's make sure that the people who are working with us are properly registered and they've went through the competency testing. I think you guys will know it. And then also practical example of non-compliance with this Rule 5.6. We have seen that registered professionals, they partner with individuals who hold architectural qualification, who are eligible to register with SACAP, but chooses not to register. So what you're doing, you are enabling somebody to do work through you, which we are saying that it is wrong. You are contravening Rule 5.6. And then we have seen that there are quite a number of complaints that we've received at the legal department, where we've seen that a person is not registered, but they are saying that, no, I actually work with so-and-so who is registered with SACAP. And then we go to our database, we are looking for that permission where you are asking to work with that so-and-so, we don't find it. And then now you're subjected to a complaint of improper conduct, you are subjected to disciplinary proceedings. So you should avoid that. If indeed you need to work with somebody who's not registered, seek permission from SACAP. Okay, so with regard to our best practice recommendation, how do you make sure that you comply with this Rule 5.6? What you need to do is, when you find someone that you can work with, just check their registration. Is this person registered? Also, what you need to do is that seek permission from SACAP. SACAP will not hold permission unnecessarily. If you come to SACAP and say that I want to work with this individual, and then there is a reason for you to work with them, SACAP will look at that and then will not withhold permission unnecessarily. So what I can say as I end my explanation in terms of Rule 5.6 and ensuring that you comply with the Rule 5.6, is just you must always remember professional registration is more than a legal requirement. It's a commitment to competency, accountability, and protection of the public interest. ensure you are registered and ensure that you are working with a person who's registered and you're enabling a criminal act. Thank you.
Thank you, Ms. Mashile. This matter happens more often than not. It's a simple rule, but knowing our history as a country, there's individuals that have been doing plans for many years that have stood the test of time. But giving or signing their drawings and their documentation, unfortunately, they do need to be registered with SACAP. We do have a channel recognition of prior learning that they can process. So please ensure that you only conduct relations with people that are registered. It's only there to protect the public. We'll then move over to item 511. This is the practice letter, the compliance. This will be done by Ms. Boitumelo Leshabane. Thank you, Boiti.
Thank you very much. Thank you very much, Madam Chair. I will be concluding my presentation with Rule 5.11 of the Code of Conduct, and this focuses on letterheads. The provision of 5.11 provides the requirements of what a letterhead or an architectural letterhead should contain. I will read it as is from the Code of Conduct. The letterheads of the practice should display the following. Rule 5.11a, name of the architectural practice, practice number, type of practice, the names of the principals and their registration numbers. B, the category of registration of the principals using the prescribed titles. Firstly, professional architectural draftsperson. Secondly, professional architectural technologist. Thirdly, professional senior architectural technologist. And lastly, professional architect. C, the professional designation and qualifications of all principals who are not registered with council should be contained on the letterhead. D, the letterhead must also include the physical and postal address, telephone numbers, email, CIPC and any added text registration numbers, and this is if it's applicable to the specific business or company. Sub-rule E, registered persons shall use their titles and SACAP registration number in all architectural reports and other documentation relating to their work in the architectural profession prepared by or for them. Sub-rule F, practices or registered professionals may not display the council's logo on any corporate stationery or letterhead, as it is protected in terms of trademark laws. Now, the question would be, why does letterhead matter? A compliant letterhead identifies the architectural practice. It verifies professional registration. It assists clients in confirming legitimacy. It demonstrates professionalism and ethical conduct, and it also reduces the risk of misrepresentation. Failure to comply may constitute improper conduct under the SACAP Code of Conduct. I'll proceed to deal with each sub-rule or each section in order for professionals to understand what their obligation under 5.11 entails. So Rule 5.11a states that every letterhead must display the name of the architectural practice, the practice registration number, the type of practice, names of all principals, and registration numbers of the principals. This information enables clients and authorities to verify the practice registration status. Secondly, Rule 5.11b, the category of registration of principals must be indicated using the prescribed SACAP titles. So in terms of the Act and the Code of Conduct, SACAP recognizes 4 categories of registration, namely professional architectural draftsperson, professional architectural technologist, professional senior architectural technologist, as well as professional architect. Rule 5.11c, where principals are not registered with SACAP, the letterhead must indicate their professional designation, their qualification. This ensures transparency regarding the professional status of all principals associated with the practice. Rule 5.11d, The letterhead must include the physical address, postal address, telephone number, email address, CIPC, and VAT registration number. This information promotes accessibility and accountability. Rule 5.11E, registered persons must use their professional title, their SACP registration number on all architectural reports, professional correspondence, drawings, and other documentation related to architectural services. This enables verification of professional registration and responsibility. Rule 5.11F, practices and registered professionals may not display the SACP logo on letterheads, business stationery, or corporate branding. The SACP logo is protected by trademark laws, and its use may falsely imply endorsement by council. So these are frequent contraventions of Rule 5.11. Omitting SACP registration number, using the incorrect professional title, failing to indicate the practice type, using outdated registration information, displaying the SACP logo, and not identifying principals properly. Such omission may mislead the public and expose practitioners to disciplinary action. Now, as SACP, we've provided a sample letterhead layout of a compliant company that is compliant with Rule 5.11. The company name is ABC Architects Pty Ltd. It contains the practice number. It contains the practice type, which is professional architect practice. There are two directors in this organization, namely Jane Smith. She has included her SACP registration number. The second director is John Doe. He is a professional architect, and he has included in the letterhead his SACP registration number. The letterhead contains the physical address, being 10 Main Road, Johannesburg, the postal address, PO Box 100, Johannesburg. It contains the telephone number, the email address, the CIPC registration number, as well as the VAT number. This format satisfies the essential elements of Rule 5.11. Thank you very much, Madam Chair.
Thank you, Ms. Boiti, for concluding Rule 5.11. Colleagues, it is quite a simple breakdown of what you need, but very, very often RPs do not have it. So along with Rule 4.1, which is the contract, 5.11, without fail, 99.9% of the cases that we charge, all the cases that we investigate, Rule 5.11 is almost an instant charge because RPs don't follow this. Please ensure, because it identifies the responsible professional, it also prevents misrepresentation, it also confirms registration category, and it demonstrates actually professionalism. It demonstrates that this practice, this company, this individual is complying with the regulatory body requirements. Please ensure our letterheads comply with Rule 5.11. Moving over now, we're moving quite quickly, actually. Rule 6.3, this is compliance with the built environment legislation. How important that is will be explained and discussed by Ms. Bessie Hlophe. Ms. Hlophe.
Thank you. Thank you so much, Madam Chair. And again, thank you to everyone for being here with us today. As the chairperson has introduced, I'll be taking you through Rule 6.3, which deals with regulation compliance. Now, the rule itself provides as follows. Registered persons shall, in the performance of their duties, comply with the National Building Regulations and Standards Act, Act 103 of 1977, Town Planning Schemes, National Heritage Resources Act, Act 25 of 1999, and any other built environment laws and any other applicable law governing the works. And then I will take you through a breakdown of the meaning of this rule. The National Building Regulations and Standards Act addresses the issue of safety, health, and functionality. And the Town Planning Scheme stipulates land zoning and zoning compliance. National Heritage Resources Act deals with the protection of heritage sites and relevant application processes. Other applicable laws: it is important for registered persons to familiarize themselves with all the relevant municipal bylaws in the area of any project, as well as to keep abreast with homeowners association rules where relevant. Before I even go on the key focus, most of the cases that we received that touch on this rule is where a registered person is involved in a project where there was building in the absence of approved building plans, and also in instances where the members of the public lodged complaints, and in their complaint affidavit, they will cite that the registered person did not understand the municipal requirements with relating to the plan, which led to the plan to not be approved, or which led to the plan to be rejected numerous times by the municipality and or the HOA. And then the key focus, familiarization. Registered persons must know HOA rules. Obviously, the essence of this is to say, before you start a project, it is important that you familiarize yourself with the applicable rules that you need to know in order to obtain approval for that specific plan. We do understand that it doesn't mean that once you submit a plan, it will always be approved from the first submission. There can be corrections, there can be amendments. However, we look at these cases on a case-to-case basis, and we also liaise with municipal officials when we are doing investigations to see if the problem was with the professionals' understanding of rules and or negligence to actually familiarize themselves with understanding municipal bylaws and also respecting heritage site laws. So municipal bylaws in South Africa regulate construction activities at the local level, covering issues like zoning, building permits, noise, safety, and heritage protection. For registered professionals under SACEP, compliance with these laws is non-negotiable. Failure to secure approvals results in liability for the professional and not only the client. SACEP's accountability principle. Since SACEP's jurisdiction is over registered persons, clients are not faulted when works proceed without approval. Instead, registered persons are held accountable. I did mention that one of the many complaints that we receive is that a client will then mention in their complaint affidavit that it was the professional that advised me to start building in the absence of approved building plans. Sometimes they don't even have to say it directly. You might find that it's very clear from the complaint itself where the member of the public is saying, I was already building, or I've started building after he gave me the draft plans before he submitted to the municipality, and now the building works are incomplete and the plan is not approved. So obviously from an investigating perspective, this does then say to us there's illegal construction that has happened here. So because registered members of the public are laypersons, and that's how we will say, they are not responsible for complying with the national building regulations, because that rests on you as a professional. So it's very important that as a registered person, you also protect yourself in such instances, communicate with the client in writing and make it clear that you're not allowed to build in the absence of approved building plans. Some professionals actually include this in their contractual agreements, which is a very efficient thing to do. And then in instances where the client is still insisting to build, despite your advice, then as a professional, you can't be involved in illegal construction works, nor can you be involved in supervising such works, because that is a disregard of the national building regulations. It is the responsibility of registered persons to safeguard themselves by ensuring that approvals and plans are in place before beginning or continuing any works. The best practice for registered persons: stay updated on laws, regulations, engage municipalities early on the project. It's much easier when you communicate with the municipalities and understand their expectations. And then in certain instances, even issues that you had not seen on site, then they can be able to let you know in advance what is required on that specific site before you even submit a plan. To avoid the back and forth as well. Consult heritage authorities whenever necessary and document compliance for the purpose of accountability. This also relates to having your evidence to show that you did all you needed to do in relation to any project. Communicating with the municipality also, you'll find a lot of professionals that will say to us, I've been talking to municipal officials, but you don't have anything in writing to show. So I would give an advice to say, if you're having an issue, put it in writing. If you're following up, follow up in writing so that you have this evidence to show that any delays or any non-understanding is not necessarily from your side as a professional. Why compliance matters? It protects the public safety and heritage. It avoids legal disputes and penalties. It builds trust with clients and communities and safeguards the professional's career and reputation. Thank you, Madam Chair. That would be my comments on this issue. Thank you so much, everyone.
Thank you, Ms. Bessie. Yes, compliance with the built environment legislation is the utmost importance. Compliance to that is the protection of life. It's a health and safety requirement. These minimum standards that are put there to ensure that structures are safe and they are fit for purpose. So the legislation ensures that developments are safe and fit. Thank you, Ms. Bessie. I also wanted to just go back to 511 with regards to the SACAP logo. I needed to put a definition in that we are required to also display a privy seal. When you display your privy seal, which has the SACAP logo, that's okay, that's fine. When the logo is on its own is where the problem is. I just wanted to clarify that for colleagues. Then we'll move over to our last item, section 18, SAPS, Mr. Funani Rekgotso, who deals directly with the SAPS on criminal procedures for people who are not registered with SACAP. He'll take us through this presentation, and then we'll conclude with answers and questions. Thank you, Mr. Rekgotso.
Thank you, Chair. Good morning to everyone. I will be presenting about the criminal matters. To protect the integrity of architectural profession, SACAP take initiative to report people who are practicing architecture without being duly registered. I will be reading from section 18, subsection 2, and it reads as follows. A person may not practice in any of the categories contemplated in subsection 1 unless he or she is registered in that category. So that one is so plain and straightforward. I will read subsection 26, subsection 3. It says, a person who is not registered in terms of this act may not A, perform any kind of work identified for any category of registered persons, pretend to be or in any manner or allow himself or herself to be held out as a person registered in terms of this act, use the name of any registered person or any name or title referred in section 18 or 21, perform any act indicating or calculated to lead persons to believe that he or she is registered in terms of this act. That was the legislative mandate of the legislative framework of offenses from our leading act, the Architectural Profession Act. It incriminates performing architectural work without being duly registered or misrepresenting yourself as an architect while you are not registered. So we always advise the RPs to ensure that when they take candidates who are duly registered. We have referred cases of unregistered people to the SAPS, and last year we had 2 convictions in Palm Ridge and Hamenas Magistrate Courts. 27 June last year, Nomsa Kate Jailer was convicted for contravention of section 18, and she was found guilty. In 1 August 2025, Mr. Wally Brown was convicted for contravening the same act, and he was fined for 3 years or 3,000 fine. So we are continuing to liaise with the SAPS and NPA, and they are supporting us in solving the cases of contravention of Architectural Profession Act. That was my brief presentation about the criminal matters. Thank you, Chair, and thank you to everyone.
Thank you, Mr. Lekgotso. It's good to know that we have a dedicated department that's there to protect the profession. You know, it's rather unfortunate. There's people who can't go walk into a hospital and pretend to be a surgeon, or walk into a courtroom and pretend to be a lawyer, but it seems that everyone thinks they can design and produce plans. Colleagues, that completes our presentation for this Code of Conduct webinar. I hope it was informative. I hope it was clear. I hope we've understood what's been trying to be communicated today. We couldn't cover all the rules in our Code of Conduct. We hope that you, through our explanation, having been able to access a way to access the Code of Conduct, please ensure you are updated and you know. I'll now hand over to Ms. Bessie, who will take on the questions and answers that anyone has. Okay, we have a hand up. Kgalego Somo.
Hello, everyone. I have a couple of questions. The first one, which category gets the most complaints, and is it a trend?
Ms. Bessie, will you take that one or should I?
You can take it, Madam Chair. Maybe you can come in after. We don't necessarily have the stats prepared for today, but we do receive a lot of complaints against persons registered in the category of professional architectural draftsperson. We also do receive a lot of complaints for persons registered in the category of candidates as well. Maybe you can add on more, Madam Chair. Thank you.
Correct.
But
No,
it's
I'll
across, yeah.
I'll confirm definitely. Our architectural draftspersons receive the most cases. Candidates, absolutely. And surprisingly, second in line, I'd say architects, professionally registered architects, which is a surprise. But yes, those are the complaints that we receive.
Okay, yeah, because I think the reason that led me to ask, I also had the same assumption because draftspersons are very limited. So perhaps maybe look for a way to assist them in terms of what we need in order to have access to opportunities, because sometimes it's a matter of frustration. A hungry man gets desperate. The second question that I have, sometimes a person comes to a practice having gone to a learning site, only to find that the learning site is not recognized by SACAP. So how do you assist that person to become registered? Because the person cannot register as a candidate because they have not gone to a recognized learning site. How do you assist such a person to become registered?
Thank you. What I do know, sir, is that this is an issue. I mean, recently we received something similar to this also about a learning institution that's actually misleading people to believe that it is recognized by SACAP, whereas it's not. So unfortunately, we do not have somebody here from the education department that can give more insight, but I know that SACAP is creating awareness as well on this issue. The education department goes around and also does presentations and awareness sessions to educational institutions, schools and universities as well. But I think we also need to expand to not only to where we are recognized or to the schools that we are recognizing, but general awareness, because this is an issue and you find that a person has spent many years thinking that they are going the right route and then they come back later and have an issue. But there is the apprentice program as well. I just don't want to comment a lot because we're not fully versed with the registration department, but maybe I can ask that I also get more input from them as well, and then give you also feedback on this so that you can also assist the relevant person. I'm just not sure I can get your full email address. I can see your name, your full name. That's what I've written down so far. Thank you, sir.
Yeah, it's my name and surname @gmail.com.
Perfect, sir. I'm writing it down. Thank you.
All right. And my last question, well, one before last, it's about the PP exam. So how long can a candidate remain a candidate? Because sometimes a candidate will serve the candidature period and have to write the PP exam. But the PP exam, it's not easy. So say they keep on failing it repeatedly, how long can they remain on the program as a candidate?
Thank you for your question. I'm just going to ask the team to also note this question for me so that we can also give you the policy afterwards that talks to the registration of candidates. So what we do know, again, this is more of the registration or the education department, so you'll just bear with us.
Okay.
In terms of the policy, a candidate can be registered for, I think it's a period of 3 years. However, the issue is that you find it's not a specific rule in the code of conduct that we can say now, for example, you are charging a person because they've been registered for a particular period of time. But the policy itself says that after they've failed to ensure that they are upgraded after that period, then their registration must be cancelled and then they must restart the process. So we do receive a lot of cases whereby we can see that the registered person has been on the system as a candidate for a while. And then what we do from the investigating committee perspective is that we will flag such candidates to the registration department so that they can either give them an opportunity to upgrade for a specific period of time. But I think maybe we can get more feedback from the registration unit for you as to maybe what are the latest progress that they have on this issue.
Okay. Lastly, these are specific questions. I would just like to ask them together so that I can just hold my mind. The first one was to Ms. Wheatman. When she spoke about CPD, she says it improves employability. That was general. I did not understand what that means in terms of the CPDs. And the last one to the presenter about SAPS. Do we have percentages of the successful prosecuted individuals? Because it's frustrating to be paying members of SACEP and people are out here practicing without having to pay SACEP, and we pay SACEP for SACEP to protect us, but it's sad to see the long list, because SACEP used to release lists of non-compliant people, but we got a presentation of only 2 people recently. So do we have a percentage of the number of people who have been successfully prosecuted? Thank you.
Thank you very much, Madam Chair. If I captured it correctly, the question is, I mentioned in the presentation that CPD assists in employability. I just want to make sure that I've captured the question correctly. Is the question that how does CPD assist in employability?
Yes.
Is that have I captured it correctly?
Yes.
Thank you very much, sir. So CPD improves employability by ensuring that professionals remain competent, relevant, and competitive in their field. I have indicated that because of it's tried that there are a lot of changes in the architectural industry. Technologies change, the manner in which things are done, it changes. If you're conducting research, for instance, which is an activity that assists with the CPD, mentoring, doing research, writing articles, that is improving your skills. And therefore, if you are a prospective employee, you are applying to SECA, for instance, or you are applying to any other institution, that will assist you because you are able to showcase improved skills that you've acquired through CPD activities. Thank you very much, Mr. Chair.
Thank you, Ms. Neo. And then the question on SAPS, the percentage of successful cases, Mr. Rikhotso, do we have that figure at hand?
Thank you, Chair. We didn't prepare stats for SAPS cases, but I want to inform Mr. Somo that there are so many cases that have been enrolled in courts, and we hand over the case to SAPS. From the SAPS, the docket is taken to the NPA, but we have a number of cases that have been enrolled. It means they were found fit to be prosecuted, but then it's not within our control. It is beyond our control as to how the case will be administered in court. I don't know if you are answered, Mr. Som.
Can I ask, is there a way that we can follow up on what cases have been enrolled and how the cases are going? Because they're a matter of public record. Like, can you share with us how we can follow up?
Yes, so what we do is, as much as the mandate on our side is to ensure that the matter is referred to the police and that the case is registered, we still do receive requests to attend in court, which we do. We also do try to do engagements on a quarterly basis with the NPA as well as the SAPS, so that we're creating awareness on them understanding this contravention of the Architectural Profession Act. So we do follow up. Maybe what we can do, because on our social media, we normally only post about the convictions, we'll inquire what type of updates that we can provide to registered persons, so that it's not only just convictions, so that once we receive a case or there's an arrest, we receive a case number, we also see if maybe that information can be shared, so that registered persons can also see that definitely each time when we receive a complaint against an unregistered person, we always obtain an SAPS number, we always open that case. It's just like Mr. Rikhotso saying, on the other side, it's a bit slow, but we are trying to push with these engagements. But maybe we can ask what type of more interactive type of posts that we can do so that you stay updated on this issue, sir. Thank you.
All right, thank you.
Thank you, Mr. Somo, for your questions. Please be aware that as RPs, if we know anyone, if we see anyone practice without registration, please inform SACAP. You will stay anonymous if you'd like that. All right, then we'll move over to Mr. Okay, Ms. Pinda Shabangu. I'm not sure. Pinda?
Good day, everyone. I hope you hear me.
Yes, you're audible, sir.
Okay, thank you so much. I just want to ask, quite a number of times through your offices, and I'm a Swazi, I'm practicing in Swaziland, but I sometimes get some projects in South Africa. So I just want to know, because I only learned, I was listening last week Friday about the registration and how should we compile our projects in terms of being recognized by SACAP. Okay, I just want to know, is it possible for me to register as a Swazi, and what do I need?
Okay, with regard to being registered in Swaziland, South Africa now currently, in terms of the Architectural Profession Act, the requirement is that whenever you practice here in South Africa, you should adhere to the South African laws of South Africa, which is Act 44 of 2000, that says that if you are practicing architecture in South Africa, you need to adhere to that. You need to be registered with SACAP. So also, if you are going to, yeah.
Okay.
Are you answered? Yeah.
Yes, I'm answered. Okay. So one should, if because what I'll need from it, just to know one other thing, is just do one needs to be qualified to in terms of the what can I say, put it in terms of tertiary qualification. Yes, tertiary qualification. Are there some stages where now I need to have to be a professional architect? Do I need maybe master's architect? What? Can you maybe briefly explain to me? I know it's out of the subject of today, but can I just maybe given time, or maybe just assisted at the site after the meeting? I don't know.
Yes. Okay. I think maybe perhaps you should. I will. I'm writing your name down so that you can be assisted on the side, because I am not. Yes, I'm not an expert in the subject, but what I know is that there are platforms, or there are programs that you can register under. But so, what is your email address? How do I contact you?
Pinda Shabang, or my email address is pinda pinda@gmail.com.
Okay.
Yes.
Thank you.
Thank you.
Thank you, Mr. Shabangu. We'll now take Anthony Papagiorgio. What is your question? Anthony?
Hi, I was muted, sorry. Where can we download your presentation? Hello?
Yes, thank you, sir. Oh, sorry, I wasn't sure you were taking it. You can go ahead, Ms. Malachi.
Okay, this video in particular will be uploaded onto our YouTube channel. A link will be sent to all attendees on via MM. And in terms of the presentation itself, we can share it through our stakeholder relations for the actual presentation, but the video will be uploaded onto our YouTube channel. Thank you.
Thank you very much. Bye.
Thank you, Anthony. Robert Bruce.
Good morning, ma'am. I'd like to thank everybody for a very interesting presentation. I have 4 questions, if I may. The first one is, could I have a response from the people around the table? When a senior architectural technologist is asked to design a community center for a retirement village, finds that her plans are not acceptable at the local authority because she hasn't complied with the number of ablution facilities required in terms of the National Building Regulations, walks away, changes the name from community center to clubhouse, resubmits. is that morally justifiable? And would that be a contravention of the Act or of your concerns? Just in principle.
Thank you for the question. I think in principle, it's obviously the merits of the case or the matter do come into play, but in principle, it is it does lack integrity, but it's easily solvable because we have a document referred to as the identification of work document, and you can't just change a name in order to comply. We check what the drawing is, what the project entails, and if it falls within the scope and description in terms of the identification of work document, which you can also access on our website. And then it will state that, this is beyond a particular scope. So a person won't just get away with it just simply by changing the name. I don't know if this answers you.
Thank you, ma'am. It gives me a guideline on how to assess this one. Question number 2. Professional architect has a client architect agreement which complies completely with the requirements of SACAB, but believes that the requirement for professional indemnity insurance is not only an expensive item, but with long-standing clients, gives his client a choice to pay for the professional indemnity insurance for that project and their involvement with it, or not, and that they would accept it as a disbursement. Is that an acceptable principle?
No, it is not. Thanks for the question once more. It's not an acceptable principle. The onus rests on the registered person to ensure that they have professional indemnity insurance. We'll just refer you to rule, I think it's a 4.1. Yes, 4. Okay, so rule 4.8 reads as follows. Registered professionals shall take adequate and appropriate professional indemnity insurance to cover all architectural work undertaken. The onus, the responsibility, and the duty is upon the registered professional. They cannot put it as a disbursement to their clients. It even is amplified by Rule 4.1, which says that in entering into a written agreement, 4.1 I states that you need to include the details of your professional indemnity insurance, including the name of the insurer, the name of the insured, the amount of cover, policy number, and validity period. So no, it is not acceptable to put that as a disbursement to a client.
Can I raise a point that the clients have made, and that is the word adequate? If you have been working with the client for 20 years and there has been no cause for any concern, surely it should be the client's choice not to generate an overall cost. It's a question in law of interpretation of the word adequate.
Adequate, even as determined by the insurers, adequate relates to the project at hand, the cost of the project or the estimated cost of the project would determine what adequate would mean. And having a long-standing client, unfortunately, does not exempt anyone from this rule, because we have seen, even in recent times, buildings that fall apart where certain architectural professionals have been involved in these and have been found wanting, clients who take shortcuts, all of those things, and then lives are lost and investigations, and it becomes a bigger thing than a SACAB inquiry. So unfortunately, professional indemnity insurance is not, you cannot put it as an option only based on the longevity of a partner, of a relationship with a client.
Thank you for your answer. When a professional architect or any of the architectural categories a person in those categories is approached by a client and finds it convenient not to assess whether a building is more than 6 years old, and fails to inform the client and fails to inform the Heritage Authority, would you consider that a contravention of his ethical responsibilities?
Yes, it is it's a contravention of Rule 1.2. It's a contravention of Rule 6.3. 6.3, just as a reminder, stipulates that registered persons shall comply with the National Building Regulations and Standards Act 103 of 1977, Town Planning Schemes, National Heritage Resources Act 25 of 1999, which is what I think you're making reference to, and any other built environment laws or any other applicable law governing the works. So yes, it is definitely a contravention.
Thank you, ma'am. And then finally, a professional architect working under an implementing agent, correspondence with the implementing agent for more than a year, asking for consideration and approval of necessary variations to the contract, and doesn't get an answer from the implementing agent. Is that professional architect then entitled to go over the head of the implementing agent and approach the implementing agent's client? I believe that my interpretation is that when the implementing agent fails to respond to written inquiries that affect the budget and the program of a project, he is obliged to then inform the principal for whom the work is being done, in this particular case, a municipality.
Okay, thanks for your question. In order for me to answer it adequately, kindly elaborate on implementing agent for me, if you don't mind, as it's a term that we don't really use.
Okay. In this particular case, a municipality has appointed a professional in another one of the built environment categories, a quantity surveyor and a project manager, to take over the responsibility of the municipality in running a contract. And the sub-consultants are all required to work through the implementing agent. So there's a contract between the municipality and the particular professional who acts on behalf of the municipality, also has a quantity surveyor's interest in the project, but fails to actually respond to any inquiries about variations that become necessary because of the nature of the heritage building, where when you have opened up a particular aspect, say, you need to do other work that was not billed for. In other words, a variation to the contract. And as a result of not getting an approval from the implementing agent to carry on, the project then stops in that particular field. And when that becomes 10, 12 items, the whole project stands still for 6 months, which is not to the interest of the municipality. So it's a difficult one, and I apologize for throwing this curveball to you.
Yeah, it is.
Now can I take it, actually?
Yes. Yes.
Okay, I've also tried to say maybe you can elaborate further on email on the comments. For me, my view is there's a contractual agreement here that is in place between yourself, as well as either the municipality or as well as either with the implementing agent. The problem is we don't have a full view of that contractual agreement, but from my understanding is that you have to do your part as the registered person in terms of the architectural work that you are employed or have been employed to undertake. And it's it's difficult for us to say go past the implementing agent who is responsible for all communications and updates and so forth, and that's their contractual obligations in this agreement. Maybe what we can ask from you is the terms of appointment between yourselves. Do you not have clauses there that speak to how you can escalate and how you can deal with disputes and or issues that you come across through the appointment? Because now we are not necessarily we do not have this information in order for us to determine whether or not it is either ethically or legally okay for you to now bypass the person that is responsible for communicating back to the municipality as the client. Yeah, thank you.
Thank you, Ms. Rope. I understand your problem, and I will probably be in communication with yourself. Thank you very much, ladies and gentlemen. Thank you.
Thank you, sir.
Thank you, Robert. Thank you for your question. We'll then move over to Kabelo Lebona.
Good morning, everyone. Thanks for the wonderful presentation. Indeed, one learned a lot, and I hope one will definitely move with what one has learned today in ensuring that we adhere to all the regulations or other rules that are stipulated today. My question, or rather clarity, or rather advice that I actually kindly request from you on how to handle the situation that one is facing is as follows. Currently, I'm staying in Jagersfontein, and it's a rural area in the Karib district, a district in Free State. I have a serious problem this side where architectural professionals are actually undermined, because at the present moment, the municipality is accepting or rather approving plans that are drawn by people who are not professionals. And it's in some instances, people who are from Lesotho are the ones that are actually drawing these plans for clients, and they are also building these plans, which I when I listen to the last slide, it is actually contravening in regards to Section 18, Section 26, and Section 41, and also in regards to NBR as well. So I made means to go to the municipality to go and do questions, actually ask questions about this situation. Instead, the response that I received, they said it's a council resolution that was taken way back. But then now the same council resolution, it's not in line with the legislation. I'm actually interested on the point that was said earlier before Rule 5.1 that stated that at the end of the day, we need to protect the public and ensure that the public is safe. But at the same time, the municipality, or rather the district in general, because we are having 3 sub-districts here in Karib, but they are just approving plans that are drawn by people who are not registered. And I'm glad that the last presentation spoke about cases that were submitted and successful cases where people were convicted. So I just wanted to check there as well. How should one go about in terms of reporting these cases? Or is it only SACAP that has to report the cases, or I should be the one who is actually exposed to this, who can actually report these cases? And then thirdly, what I also want to check is the issue of the written contract. I heard on one of the slides where it mentioned the guidelines of professional fees on how we should do that. That also, it's a challenge on our side, more especially as architectural professionals this side, because we are competing with people that are actually unregistered and who are unprofessional. At the end of the day, we end up not adhering to the guidelines of the professional fees as outlined in the Government Gazette. Hence, we end up having prices that are not in line with the stages, because we need to do 6 stages. At the end of the day, we end up dropping the prices to a way that will actually accommodate the clients at the point that we should not actually lose our clients. So I just want to check how best can you advise one, and how should one go about in terms of tackling all these issues. I also wrote letters to the municipality since the beginning of the year, but up to so far, one has never received any response. Even yesterday, yesterday, I wrote a letter to the Speaker of the Kopanong local municipality as a way of doing follow-ups, but one is not receiving any feedback or any written response. Thank you.
Okay, I'll try to answer the second one because I think I understood the second one, but we'll just refresh my mind with the first one, and then Mathibula will take the third one, right? Okay, the second one, you wanted to know if is it SACAP that can you go and report to the police about an unregistered person? Unfortunately, you need to bring it to us, and then we will then go to the police station and then report the case, because we are taken as as a regulatory body. This individual that went and practiced architecture without being registered has contravened our prescript. So our legislation, which is 44 of 2000. So how you can report this case to us is that we actually also have an anonymous form on our website that you can complete, and then you give us all the details, give us all the evidence you have to show that this person is practicing without being registered, and then we will take it from there. The command records will then take it from there, and then actually will go to the police, and then SACAP will be the victim, and then we'll then report the case to the police, unless if there is a fraud that you've also experienced, then that fraud you need to report it.
Thank
and then the first question, can you just maybe help me with the first question?
The first question was in line with the same response of people who are practicing without registration. I think I'm covered there.
Oh, okay. Thank you so much.
Thank you, Kabelo. Kabelo, when one looks at your third question, it appears that the lamentation is basically about you as a registered professional having to compete with unregistered persons, which then makes you somehow compromise yourself in the way in which you charge your fees. I think I summarized it properly. Look, the intervention that SACAP makes with regards to unregistered persons is that we report them to the police. Other than that, there is absolutely no cure in which we can stop people from practicing illegally. We simply can do so much, but other than that, it really lies upon the public itself. The public must know not to do criminality. And like I said, the only way in which we can try to deal with criminality is by referring these cases to the South African police, with the view that ultimately these cases will go to the criminal courts. I don't know if I got you correct, sir.
No, thanks a lot, Mynheer. You covered it correct. Thank you.
Kabelo, if you can maybe just indicate what municipality is this again that you mentioned? If the municipality themselves aren't aware of what our regulation is, then we can propose engagements with them. What municipality is this?
Okay, the municipalities are Kopanong local municipality. The second one is Letsemeng local municipality. The third one is Mohokare municipality.
All right.
Can you repeat the last one?
Mohokare municipality, Mohokare.
Thank you. Hopefully we'll assist in getting this resolved. Thank you, sir. Tsepo Lucky, what is your question?
Hello. Am I audible?
Yes, you are, sir. Please proceed.
Yes. My question is about municipality, in terms of approval delays of the municipality. We have issues with like our current municipality, the way like plans are not getting approved and they take time, and homeowners are frustrated. They feel like that we are like kind of misleading them. We're not doing anything as much as we communicate with them. But at the end of the day, the results are not coming. So my question is based on that, because I remember SciCap had a team that was helping people in terms of approvals with the municipality. But now somehow it's kind of disappeared. We don't know anything. And yeah, I just want clarity about that, and how can we make our clients easier, because we've been communicating, we're sending emails. It's like it's a back and forth, and it's not nice. And some of them, they are moving from their houses. They bought a new house. They want to appoint an architect to design for them. So now all that process is being delayed. And some of them, they will end up like building without us knowing. And that's what another thing I just needed to ask, if in an event where like we did everything to the T according to the bylaws or code of conduct, but due to the time that it's taking time, and there's no results. So I just need understanding about that part in terms of where's that team that would needed to help. Yeah. Okay. Thank you.
Yes, Tsepo, thank you for that question. We still have the team. So what you can do is that you can send an email detailing exactly what happened, which municipality, and the team will be able to help you. So the team is still there.
Yeah, but it's not agile.
Okay, you send the email. Okay, maybe you can send the email. Send the email to legal@sacapsa.com and see if that will not assist. But I can assure you we will be able to help you. Just give us details.
And then another thing, just to understand, give us the breakdown. What do they do? Are they coming there with the maybe upper hand, or what are they doing? Because the last time the guy, there was an issue that the SECAP team is just sending emails. They were not even going to that municipality. So maybe the breakdown of what powers are they coming with, so that maybe things can work.
Okay. Mr. Lucky, I'm not part of the team, but what I can tell you is that I think it's better to have your own experience. Perhaps send the email, and then we will take it from there, and then you see if the team will assist or not. But I can assure you, you send the email, and then we will be able to assist. And then you have your own experience with regard to the team.
Just to also add, Lucky, you must also remember that municipalities don't necessarily account to SACAP. We don't regulate municipalities. So SACAP's interaction with municipalities is on a cordial engagement level. So it's not about SACAP having an upper hand of some sort. It's just to bring to their attention to say there is a concern from the profession about this and this and that, and then probably put on the table some measures to sort of resolve the issues. But we cannot claim to have an upper hand. They don't report to us. We cannot in any way sanction them if they don't play ball. Thank you.
Well, so you're just saying that you guys, SACAP, you're going to engage with them via emails and stuff, or maybe see, but there's no because we need results. anytime of being talking, we're going back and forth. We need results. People need results, especially when they've paid. You know, homeowners, when they paid, they expect results. And when we engage with you guys, with big institutions, we only get this thing that we engage with them and what. And I even had the successful rates of people being present and what. It's been that state. It's always been that state. Yeah, and before I go, if maybe one has a problem with maybe SACAP in terms of their flexibility, and how can we? Because at their own, mostly, or I feel like I'm alone in this thing. I'm paying fees, I'm doing everything to the T, but at the end of the day, yeah, thank you. I think I rest. Thank you.
Thank you. Thank you, Mr. Lucky. No, we do feel your frustrations. This is a national issue with our municipalities. We do have road shows, we have engagements physically. We don't only write emails, but as Mr. Sfanele says, they are not contracted to, we don't have a law that they must listen to us. Ultimately, the operations rest within the municipality. So we're not quiet about it. We are aware of the issues that our RPs face. Hopefully there'll be improvement. All right, then we move over into Ambani Mbande. Mr. Mbande.
Hello, hi.
Yes.
My question is that I needed to know on the practice that we have been practicing, but they've not sent any notification to SACAP. What must they do to correct those kind of mistakes?
Mr. Mbadi, I think if I'm catching your question correctly, you're saying that you previously were practicing without notifying SACAP. If the matter has not yet been reported, you still have an opportunity to rectify it by sending an email to grace.sibaya@sacapsa.com and inform them of your registration. Should they require any further information, they will reply to your email accordingly. Sorry?
Okay, yes, I can hear you about that. And my other question is that I heard that you say if maybe there was a complaint, you'll check when was the company registered versus the time of the complaint. And if the company was running, but it was not an architectural company, then the owner becomes a member of SACAP. Then he added that service on the existing company. Is still that fine?
Okay, sorry, just so I understand, are you saying that previously the company did not offer architectural practices, however,
Yes.
recently has started offering such services? Yes?
Yes.
Okay, well, in that instance, then if they were not offering architectural services prior, it will show in the registration documents and the services that were offered. Even if a complaint comes, we do take that into consideration to say you are not required to be registered with SACAP previously. However, when you did start offering architectural services, as you do now, it is the onus is on you to ensure compliance in terms of registration with SACAP.
Okay, thanks.
Thank you.
That's all.
Thank you. We will take 3 more hands. Let's go to Audrey April. Aubrey, sorry, Mr. April. Aubrey, you still muted? All right, let's move over then. Karabo Pizzo, what's your question, sir?
Thank you very much. I would like to thank the council for this seating. It's been very informative. And yeah, please let us know how we as registered persons can also assist in any way. I've got 3 questions here. Earlier on, and I heard that the term implementing agents was almost a new term to the council, but many tenders have been going out, right, from the public sector. Dare I name a few of these implementing agencies, but when these bids go out, let me say, for example, I'm not pinpointing anybody, DBSA, IDT, here are a lot of them, right? Who obviously from the government side of things, they would get the job, Department of Infrastructure Development, Gauteng, etc. You will find that when these bids go out, they ask for multidisciplinary. And there are very few companies in the whole country that are fully multidisciplinary, right? Very few. But we find that there are companies that are calling themselves multidisciplinary. They are absorbing all other professionals under them as sub-consultants. So you'll find a civil engineering company out here, all of a sudden it receives multidisciplinary, and then architects have to work under civil engineers now. Can I please just understand how SACEP sees that working, because it's really affecting the industry on that one. Number 2, there are bids that go out that ask for architects, but are awarded to companies that don't even practice architecture. So even in that, do we just take that bid, send it to SACEP, report it, and hope that the Competition Commission deals with it? That's number 1. Number 2, I would just like to find out, with regards to the IDOW, is it now enforceable, or are people still trying to fight for relevance when they don't have qualifications? Then the third one, when it comes to the SACEP guidelines, especially the fee guidelines, is it our responsibility as registered persons to report when we have heard or have evidence of excessive discounting, especially in the private sector with these developers? Do we report it, or is it a thing of where there's smoke, there is fire? Because if we need to come with the proof and we are not privy to the contract, we don't know how to prove that. And then just to wrap that one up as well, with regards to the payment terms, I've read the Code of Conduct and I've read the Gazette or the Board Notice 875 of 2026, of which is the latest one now. And it does not necessarily say whether you can invoice before you do the stage, or if you have to complete the milestone first and then you can only invoice, because a lot of the clients that we are dealing with, you now need to litigate all of them to get paid for what you had advanced to them as credit, basically. And to protect yourself in practice, we are not like attorneys who can have a trust account and then have money sitting in there, and if the client is not paying, we then can draw from that and then hand them back the balance. What protective measures can we take that will not be contravening the Code of Conduct or the Act, knowing that we are dealing with unscrupulous and unethical clients that we need to protect our businesses too? Thank you.
Thank you. Thank you, sir. Maybe Ms. Mashile, we will take a look together. I was also trying to make notes. Okay, starting off with the multidisciplinary practices. So one of our rules with regards to multidisciplinary practices is that if it's called an architectural practice, it must be in the hand, our majority shareholding must be that of registered persons. And then also in a multidisciplinary practice, what we expect is that the architectural department is in the hands of registered professionals, meaning that it's only registered persons, professionals that are dealing with the architectural work. So we do not prohibit the establishment of multidisciplinary practices as SACAP. We can only go with the rules of the code of conduct as to whether or not are they compliant with the rules that are set out in the code of conduct. And then with regards to you as registered persons working for engineers, as you've mentioned, unfortunately, it's not really for us to say that all registered persons should not work in a multidisciplinary practice, because from our expectations, we're trying to protect the profession by saying only the registered persons must be dealing with the architectural work of that multidisciplinary practice. And then with regards to tenders, this is an issue in the profession that you find. We've also received complaints where registered persons are saying, I've come across a situation where there was a bid and then I did submit my work for the tender, but at the end, a non-registered practice or person got the tender and then either hired or used the information of registered persons to actually get the tender. And then you find that registered persons are now not protected because when they're doing the architectural work, you find they're not getting paid. And then at the end, they can't even go to the specific department because they are not necessarily the ones that got the works. So the general output is that because we're not privy to all these tenders, we would appreciate that registered persons bring more of this type of instances to our attention as well, so that we can also look into it. Sometimes when we receive a complaint, it does not always have all the full information. We do preliminary investigations as well. And then I think as SACAP, then the more we receive this type of complaints, we can have an action plan as to whether or not do we approach departments, how do we create awareness around this issue, because we're not necessarily part of these tender processes. But from our stance, we wish to have a situation where only architectural persons are getting tenders for architectural works. And obviously, where non-registered persons are getting these tenders, we can still look at it to say, are there non-registered persons rendering architectural work, or they are involved one way or another in architectural work, which again, as mentioned, we do refer non-registered persons that are involved in architectural work to the SAPS. And then with relation to the IDOW, the IDOW is in force. All registered persons are expected to comply with the IDOW. Municipalities, HOAs, and so forth, they're all expected to comply. On the question of if there are still persons that are still trying to avoid or trying to, just trying to not comply with the IDOW, we do have those instances. The investigating committee is also dealing with cases whereby other registered persons are lodging complaints against other registered persons who are non-compliant with the IDOW. And also we do have members of the public who will then also say that I'm now aware as a member of the public that this level of work was not supposed to be taken, for example, by this professional architectural draftsperson, but they created the impression that they can do this level of work. And then we are dealing with those cases as well. So we would like to encourage all the registered persons that are here that if you do come across a situation where you see a registered person doing work that falls out of their scope of their category, you also let us know. You are allowed to lodge complaints anonymously, provided that we have something that we can work on when we do preliminary investigations, in order to enable us to actually investigate the matter and take action against such persons. But as it stands now, the IDOW is in force. Unfortunately, we don't have someone from the registration department that can maybe comment on what applications are still available for registered persons. but we can check that for you. If you are a registered person and you want to make any applications relating to the IDOW, if you can just call the SACAP number and ask for Nuran or anyone in the registration department just to see if there's anything open currently. But as it stands, it is in force, sir, and we are charging people for non-compliance. And we are also doing awareness on this every time we go to municipalities and to the community, hence why even members of the public are now saying, this person is doing work for me, but I think this work falls out of their scope, and they do ask us to confirm, and we do confirm so that we can protect the profession. And then also with regards to the published fees, I didn't really catch the full question there. If any of the members caught it, they will add on just to ensure we assist you. But from our stance, the fees are a guideline and they are only published as a guideline. So it's difficult for us to then say if a person is not going as per the published guideline, the architectural service appointment, at the end of the day, the contractual agreement is between yourself and the client, the agreement on fees and when fees are payable. That's why, as you heard from Mr. Matebula, under Rule 4.1, we do expect that in your contractual agreement, you do stipulate then when fees are payable, which would be whether it's there's a deposit. Obviously, then you will state when the deposit is payable. Is the fee, what type of percentage of fees are payable before you submit or after you submit the plan. But it's not necessarily for us, for SACAP, to stipulate that this should be done in that particular manner. Hence, the fees are just published as a guideline to just show what is the market-related or markedly acceptable fees at the time. But please, colleagues, do add on if I didn't catch this fee query properly. And then, yeah, I think I've covered that part also where you asked about when you are expected to invoice but for yourself as a professional, steps to protect yourself. It's very important that you have all these things, you have them in your terms of appointment, so that even if when the client is failing to pay you as per the agreement, you have that proof that, you know what, we agreed that you'll pay the fees within 7 days of me invoicing, for example, and you haven't done that. And then you can be also able to stipulate in the agreement what happens when fees are not paid on time, what are the applicable percentages then to such cases, or do you go for dispute resolution, or what steps can you take? But it all starts with the contracts between you guys. The best place you can protect yourself as an architectural professional is in the terms of appointment. That would be my comment on this. But please, colleagues, also come in if I missed anything. Thank you so much, sir, for your questions.
No, thank you, Space. Like I think I think with regards to that, all I just wanted to do was to make sure that I'm not in contravention of integrity or anything else when I know I'm dealing with a criminal and I want my money up front. All right. So if you are saying it's just a guideline and you can stipulate the payment terms. If you want them to pay you in advance for a stage because he might be called to the Madlanga Commission, so be it, right? So I'm glad about that one. And then with regards to the IDOW, there was a colleague of mine as well who had asked about municipalities, etc., right? So that's why I was asking IDOW, because the local authorities should be adhering to IDOW. Them approving any willy-nilly person should really be the IDOW has to be held there. I think that what I just wanted to touch on, the last 10%, was the implementing agents, DBSA and the rest. But as I'm saying, as and when those bids come out have been weirdly advertised, as we've seen that with majority of them, their supply chains have all been compromised. We'll send it out while it's still on bid, and hopefully it can be dealt with before any appointment has been made, just so that you're not called out for sour grapes. Thank you, ma'am.
Yes, sir. No, I'm with you there, sir. Definitely. And also with the IDOW, please, because again, we rely on also the eye of you all as registered persons. If you know there's a municipality that's ignoring or not taking the IGOW into consideration, please let us know so that we can also be able to address that, because so that it's fair and so that it's applicable to all registered persons. Thank you so much, sir.
No stress. Thanks, Mick.
Thank you, Mr. Pitso. Colleagues, we have exceeded the allocated time for questions and answers. We've actually doubled it. But please, if you have any queries, please contact it's legal@sacap.co.za. Feel free, get points of clarity. It's far better to get clarity first than to act and see yourself in a situation that's not favorable. So this concludes this session. I'll then allow Bessie to do a vote of thanks and closure.
Thank you so much, Madam Chair, and thank you to all the presenters as well today. Well done, guys. Though we had a bit of some sound issues here and there, please, if you have any of our email addresses, you can also ask us for the presentation and we will gladly share it with you. On my side, I think I just want to thank all the registered persons that made the effort to be here today, to actually also, this is also keeping up to date, with what's happening in the profession, and especially the code of conduct. It's a very essential document. From us as legal persons, we always say it's so easy to understand, but obviously from a registered person's perspective, where the skill obviously is not necessarily on reading a lot of documents all the time, please, we just want you to all know that we are available as the legal department to you all. It's not only that you should communicate with us if you have a complaint or there's an investigation or the matter is at a disciplinary hearing stage. We are available to you every day. Whenever you have a question, we want to help you as well, because from my perspective, a lot of the matters that end up go to a disciplinary hearing, or a lot of the complaints that we receive, you'll find that it's just the effort of asking us and finding out from our side to say, just to understand a particular rule or just to understand a particular situation. We know you are dealing with different clients. We're not saying face these challenges on your own. If you're having an issue with the client, even before it escalates, let us know. Let us see how best we can be able to assist and how best we can be able to advise you. And then I think you should just take it upon yourself, if you have a practice, just to look at mainly the administrative rules. We do try as the legal unit where it's an administrative rule that has been contravened to give you a chance to rectify that rule. But the main issue is that continuously you find that we're still dealing with Rule 4.1 complaints, Rule 5.1 complaints, Rule 5.11 complaints. So as you've seen today here, if you're not sure about how to structure your letterhead, let us know. Let us be able to assist you. Let us give you an example that can be best suitable. That's our job, to assist you. Also with the terms of appointment, I know even the Madam Chair touched on it, that as much as professionals are thinking, I'm just going to send an invoice and that's what will make my client happy rather than a big document. It's not just about it being a big document. It's only about it having those expectations of Rule 4.1. So do get in touch with us and let us know how best you can incorporate those 8 sub-rules of Rule 4.1 in your terms of appointment, or how best you can structure our project agreement so that it caters for your type of projects that you have. And then lastly, again, just to emphasize that we are available to you all at all times, and then even during the investigations and disciplinary hearings that are happening, we are still available to assist. But we thank you so much for the time that you've spent to be with us here today, and we just encourage you all to get a copy of the Code of Conduct in whenever you are on your daily goings, and then just use it as a reference to enable you to avoid simple complaints or matters that don't actually have to be disciplinary hearing cases. Thank you so much, Madam Chair, and thank you again, colleagues. Thank you all for your efforts as well, your preparations. It shows how fully prepared you all were with your presentations. And again, thank you, Madam Chair, for assisting us today. We truly appreciate your service always and at all times. Thank you, ma'am. Thank you, everyone.
Thank you, Ms. Bessie. I'll now announce the webinar close. Enjoy your weekend, everyone. Thank you. Bye.
Thank you. Thank you, Madam Chair. Thank you, everybody.